And let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon again, ladies and gentlemen. And Mr. Scheck, you may continue with your argument, sir.
Thank you very much, Your Honor. Good afternoon, ladies and gentlemen of the jury. When we left, I showed you two clips from Thano Paratus. In the first clip, he was under oath. He said when he drew Mr. Simpson's blood, he looked at the syringe. And that's how he knew it was between 7.9 and 8.1. No doubt about it. Something he does all the time, routine, something people in this field would do and know. He looked at the syringe. Then, because they couldn't live with it, because 1.5 is missing, and they could have called Thano Paratus in his direct case and put him under oath, Mr. Goldberg goes out and does this statement, this strange, bizarre statement in Mr. Paratus's home, which they tell you was unscripted, or that is to say, I mean, let's not say he gave him a script, but I mean, common sense tells you that they spoke to this man before they went and did this videotape, and you could tell at parts he literally said, I don't remember, because he was forgetting certain parts of what he, I guess, what it was planned to say. But let's get down to the substance. I mean, this is not under oath. It is the only testimony you've gotten in this case that is not under oath, which is fairly extraordinary. But you know what's even weirder? It's what he said. His position is this now. First of all, you can see the syringe, and you can see the calibrations on the syringe. So now he's saying, well, the syringe was turned over, and I didn't see the numbers. Well, that's pretty strange. But I think that what's even more odd is that it is his position that he now realized that he goofed. How does he know? He says that he took one of these tubes, now these, are items in evidence, and he looked at it. And he now remembers, months later, that when he drew Mr. Simpson's blood on June 13th, he can remember the level that the blood was in the vial. And based on his recollection of where the blood is in the vial, he then starts putting water in to another test tube to get it up to that level. And then he says, well, that's 6.5. Well, that's not worthy of belief, is it? That you can remember all these months later the exact level, and that's how you come up with 6.5? So not only is it not under oath, and not only is it obviously a convenient recantation and appears to have been prepared, shall we say, to suit the prosecution's purposes when things just didn't fit, but the story is an absurdity. It is just an absurdity. It is not worthy of belief. It is a reasonable doubt in and of itself. Blood is missing.
What evidence items are those?
This was the syringe, which is 1382, and 1124, a purple top tube of exactly the kind involved in this matter. Could we have slide number 9? So let's review the bidding. Missing blood. Access opportunity and Mr. Paratus, the smoking gun. Detective Van Adder is walking around with this tube in a May 10th envelope, unsealed, going up for coffee, 3 hours. It is misnumbered. It comes in as 18, not 17, 18, after the sneakers, which were brought in the next morning. There is at least 1.5 mil missing, no question about it, early in the game because of the toxicology entry, and then we have Mr. Paratus's unsworn recantation. Is this a coincidence, or is it corroboration that something is wrong, something's terribly wrong at the heart of this case? It is a reasonable doubt, because missing blood, I submit to you, the blood is an essential fact. an essential fact in the prosecution's circumstantial case. If you can't trust the man who carried the blood, if you can't trust where this blood went, I mean, EDTA, missing blood, coincidence, corroboration, something is terribly wrong. Now I'd like to move to the blood drops found at Bundy. And there are two aspects of examining this evidence. The first has to go to the integrity of the samples, and the second one goes to the issue of cross-contamination. First, I would like to address the issue of the integrity of the samples. We start with the handling of the swatches. And we know that they are not counted at the scene. They are not counted when they get back to the lab and put into test tubes for drying. They are not counted the next morning when they're taken out of those tubes. There's no count. First time there's a count is when Yamauchi gets it between 9 and 11:20 that morning, June 14th. So we don't know how many swatches we started with originally. And as Dr. Lee told you, as all criminalists told you, as Gary Sims told you, it is the first duty of a forensic scientist to document the evidence and to establish a chain of custody that preserves the integrity of the evidence so that you can bring it into court and good people like you can feel satisfied that you have honest, reliable evidence. That was not done. No booking until June 16th. It's in the lowest security area, that evidence processing room where that metal gate can be lifted, where yes, you have to have a card to get into the door, but other people walk in and out and the entries are not monitored. It is an unlocked cabinet, and in this phase, there is no way to trace the individual items. Now, we had asked, Your Honor, for the bindles to be produced, but they have not been produced. But you can get them. You can get them when you go back into the jury room. And there is one absolutely extraordinary fact in this case. On August 23rd, Andrea Mazzola was called to testify at a hearing in this court, put her hand on the Bible, swore to tell the truth. When she came in, she had her notes, the same crime scene log notes that she and Mr. Fung had reviewed in their testimony. She got on the stand, and she was asked questions by Mr. Neufeld about how they went about collecting the swatches and the evidence in this case. And she described the process of taking up the swatches, coming back to the lab, putting them in the tubes for drying, taking them out the next morning, putting them into bindles, and then she testified that they initialed the bindles, that she, Andrea Mazzola, took some of them, Mr. Fung took others of them, and she initialed the bindles, those little white bindles that the swatches were in. You all recall that. She said that under oath on August 23rd. And, you know, think about whether or not she would have good reason to remember and have a best recollection of what actually occurred when she testified on August 23rd. This case was the first crime scene that Andrea Mazzola had ever primary responsibility for collecting blood evidence. A good reason to remember. Between June 13th and August 23rd, when she testified under oath, Andrea Mazzola had not done another crime scene. So there was nothing to confuse her. Collected blood from a crime scene. When she testified, she knew that this was an important matter. I realized that she did not know who Mr. O.J. Simpson was, fair enough, but she certainly knew that this was an important matter and that everybody was concerned about it, and you would expect that she would want to testify in a fashion to the best of her recollection, looking at those notes. She said, no question about it, that she initialed the bindles. You will get the bindles. We laid them out for you. You can look at 52, 50, 49, 48, 47. Her initials are on no bindles. Zero. Something is wrong. Could we have the board? Dr. Henry Lee is quite a remarkable man. And we tracked this evidence His offer was not taken up, he and Dr. Batten, to examine this evidence. At the time it was collected, as the testing was going on, he did not really get a chance to examine and handle the evidence until February 16th while you're still sitting here. However, we did try to track it as much as possible, and we were allowed to take pictures at the Cellmark laboratory of the swatches, and we were allowed to take pictures of the bindles and measure them and weigh them because something was wrong. And then we found the wet transfers. This is very disturbing, as Dr. Lee indicates, because the uncontradicted testimony is that these swatches were put in test tubes to dry for 14 hours. And Dr. Lee gave you his best estimate that he thought they would dry within 3. And then Mr. Goldberg came in with, we have that study? The Epstein-Barr study, and if we go to cotton cloth, indicates that it should take about 55 minutes, if you look at it, under condition number 1, that's at room temperature, to dry. So, no. They should have been dry. I expect they'll come in and they'll say, well, there was a swatch sandwich, they were all stuck together so they wouldn't dry. Nonsense. Use your common sense. How do you get wet transfers like this? Well, within 3 hours of the time that they were taken out and put in bindles, if somebody had switched swatches, you'd see wet transfer. Now, there was a very interesting point in this trial where Mr. Matheson was asked some questions about knowledge that detectives had with respect to the collection of blood evidence. And he and both Mr. Fung testified to this, that detectives are trained in the collection of blood evidence in exactly the way that they do it at LAPD. Now, remember, the way they do it at LAPD is not the way one should do it for the collection of samples for purposes of DNA evidence. They haven't changed their procedures, as was testified by Ms. Kessler, the head of the lab, in terms of, old conventional serology testing. So they're still putting them in plastic bags and degrading samples. But put that aside for a second. Matheson is asked, starting at 25031 of the transcript, about question, when you say evidence collection technique, have you ever taught detectives how to collect a stain using LAPD procedures? Talking about a biological stain, yes. And he goes on to talk about how they want detectives to have the capability to collect blood drops, and they have an on-call system, and sometimes a criminalist, is not available, so they want detectives to swatch blood stains. And he goes on to say, and I quote, "We supply them with blood collection kits, simply a file box with the tools that are necessary to collect the samples." We're talking here plastic bags and swatches and gloves. And question, I know they are taught how to, take a control and use the distilled water and use the tweezers, the whole 9 yards. Answer, yes. They are both shown in the demonstration form. We talk to them about it. It is demonstrated to them, and if time permits, we have practiced with them within class. Question, and are detectives in fact collecting biological evidence in the Los Angeles Police Department and submitting it to your laboratory for analysis? Yes, they do. Detectives have swatches. These detectives would put them in plastic bags just like Fung and Yamauchi. If they were to be stored for some period of time, it would degrade them. Even if they put swatches with EDTA blood on them, they still degrade them. These ridiculous techniques. If they were put into those envelopes and left wet transfers, the integrity of the evidence is in question. Something wrong. Admittedly, to be fair to the prosecution, there's probably not enough sample left from the Bundy blood drops to take them out for EDTA testing. But they didn't do it. And I think you have to ask yourself a fair question, given the way the blood evidence has been handled in this case. What would those results be? Just from this, you must question, must have a reasonable doubt about the integrity of this evidence. But When you consider the evidence, we have to take the evidence as it is, and we have to reconstruct as best we can what's going on in the case, as you must, in a fair and unbiased way. And you consider the evidence, the whole issue of contamination arises. And it arises in a funny way, because one can see that if these samples had been contaminated, cross-contaminated, in a way that I know you have followed, and I will review with you, and forgive me if I repeat details that I'm sure you have followed, that certainly would convince certain people that they were on the right track, and maybe they wouldn't hesitate to tamper with other evidence after that to make the case look better. Could cross-contamination have happened on these facts? Before I go into detail, I'd like to make 2 points. Same point I think I made at the beginning, Dr. Speed made. If there was cross-contamination in the evidence processing room on the morning of June 14th when Mr. Yamauchi was handling the samples and Mr. Simpson's reference samples at the same time, or on June 13th to June 14th when Fung and Mazzola were handling these swatches, it wouldn't matter how many times you tested them after that, they'd all come back the same. So let's focus on what the issue is. It's what Dr. Speed was calling common mode error. In fact, if we could put this flow chart on the, remember the prosecution showed Dr. Speed a flow chart. It's a little hard to see there, but Mr. Harris, if you could circle the evidence processing room, this was the final flow chart. There are 2 little houses that represent the evidence processing room. That's drying on June 13th at the bottom and sampling on 6/14. And as you see, in terms of the testing, now do both. Please circle both. This is an item in evidence. The circling won't be in evidence, although I was looking for it. I could have sworn Dr. Speed had circled one, but I couldn't find the exhibit. In terms of the workflow, that's where cross-contamination, contamination occurred in the way they handled these swatches on June 13th and June 14th. And if it happens there, it doesn't matter who else tests it or how many times, you can't validate it. Because if the DNA was cross-contaminated there, it's going to come out the same every time. Now, thank you. That's point number 1. Point number 2 is the presumption of regularity. You heard that the primary answer that Gary Sims and Robin Cotton were giving on why they distrusted the explanation of cross-contamination is they said, we must assume that substrate controls were handled in parallel with the other evidence items. Now, there's a lot of problems with making that assumption. Number 1, we know that Fung and Mazzola have no training in terms of why the substrate controls should be handled in parallel. In other words, if they handled all the wet red swatches first and then they did the controls after, they didn't put them in precise order, then it no longer serves as a control against cross-contamination. So they're saying we must assume that they were handled in parallel. And if we make that assumption, then we think controls worked. Well, there can be no presumption of regularity at the LAPD on how they handle these swatches. And the reason that they are not entitled to that presumption, and well, there's number 1, Mr. Simpson is entitled to the presumption of innocence, but number 2, we have proven that they're not entitled to it. Dr. Gerdes has proven it. Dr. Gerdes came in and he did an extensive study of the LAPD lab. Let me get rid of that circle. And I won't review all of what he said, but I think it's a fair assessment of this man's testimony. That he is a solid, straightforward, careful scientist who spent hundreds of hours reviewing data, doing an inspection. And what he found is that there was a cesspool of contamination in this laboratory. No mistake about it. Cesspool of contamination. The second thing that he proved, and you get that cesspool, how can you just assume they're doing everything right when we can prove they're doing everything wrong? Next slide. The next part of his testimony that has particular relevance is the whole issue of contamination by control. If you recall, when he examined the controls, there were controls that would show that there was contamination going on at the extraction process, that is, in the evidence handling, the EPR, the evidence processing room stage, as opposed to later when the amplification occurs, or the so-called negative amplification control. And based on this data, he made the assessment that the contamination problem at LAPD is happening in that evidence processing room stage when they're handling the samples. Thank you. So we have proven that they are not entitled to any assumption of regularity in that evidence processing room in the way they handle the samples, because they are getting this contamination all the time. Dr. Gerde's testimony, I think, also proves something significant in this regard. He proved that they literally don't know what they're doing. It's a shame. They do a validation study where they're processing known samples and things like cases, and they give a report saying there are no incorrect typable results observed. And that's simply not true. And I know we went back and forth about the errors that they made, but you recall the testimony. Some of the errors they made on their own validation study, Mr. Yamauchi and the others, were of the kind that could create false positives that could convict innocent people. And they didn't even note in their own review of it that they made those errors. If they're saying they could be justified, then they should have at the least said there were some incorrect results observed, but these are the reasons. But they didn't even do that because they weren't even aware of it. Mr. Matheson, who admits no DNA expertise of any significance, is the one reviewing it. He didn't notice anything wrong. Dr. Gerdes, without going into too much, talked about how they don't change their reagents in a regular way like they do at DOJ or Cellmark or any other self-respecting laboratory. They didn't even realize that they had this contamination problem, which is even more frightening. And you did not see a witness come in to rebut Dr. Gerdes. One would have assumed that an independent scientist not associated with a laboratory would have come in here to refute his data. And they'll talk about, well, you didn't call Dr. Mullis, you know, that person would have come in. Dr. Mullis could have been a surrebuttal witness. It didn't happen. I'm kind of surprised, frankly. Now, they're going to say that, or have said, what have they said about Dr. Gerdes so far? He was paid money. He's not a forensic scientist. He's not qualified to review a DNA laboratory. Well, I think you're going to reject that for good reasons. He's reviewed 23 forensic laboratories, the work of them. He's visited 7 laboratories. He plainly knows the literature in this field. He demonstrated that on cross-examination by a very fine lawyer. Couldn't ask him one question about an article he hadn't read or assessed. He is a microbiologist, which is particularly important training. I'm sure some of you know that from your own work. And that is a person who is a student of how contamination occurs, bacterial contamination occurs, clean methods, sterile methods. He has a PhD in this field from UCLA. This man, his lab, is accredited by a number of organizations in paternity testing, disease diagnosis, organ transplants, bone marrow transplants, many organizations. Inspected, accredited, his laboratory. He understands these procedures. This man deals with life and death every day. Every day. With DNA testing. The nerve of them to say, you're not a forensic scientist. You can't assess a DNA laboratory and how they handle the samples there. That's audacious. That is not worthy of your consideration as an answer. Put on a witness, show data, get a self-respecting scientist to come in here and refute what Dr. Gerdes said. They couldn't do it, they wouldn't do it, they can't do it, and that's why you heard no one. Because he's right. And the lab, I mean, it's terrible. You can see. They were training each other, Yamauchi and Aaron Riley. They had no PhD brought in to construct this place. That's not right. That's not right. You're citizens here. We're entitled to more than that. You can't run a lab like this. You can't then get up here in closing argument and go, we have a sloppy lab. We're dealing with life and death. Just like these transplants, we're dealing with life and death. It's too late to say now, ignore all this. You can't. Now, they're going to say, he's doing it by medical standards. That's too high. Can't judge a forensic lab by the standards we used for medical DNA. But we went through this, and we know, frankly, that forensics is more challenging. In medical applications, known samples, clean samples, unlimited amounts, they're not degraded. All that occurs in the forensic situation. There's no justification for saying the standard should be lower. And even under a forensic standard, whatever that might be, and frankly, these are the standards, and you know they're not coming close to this book. Even by those standards, Dr. Gerdes offered a conclusion which I think is not unreasonable in the evidence and stands unrefuted. It should have been shut down. And that's what they're asking you to accept. But it goes further. You know, Ms. Clark said, and I frankly think, I assume she's going to be answering all this in rebuttal, it is not, after all we went through with this DNA evidence, it is not enough to say to you, because you know a lot about this now, to say, oh, they're saying something about flying DNA cause cross-contamination. Flying DNA. That is not the contention. The contention is specific. It is in the evidence processing room. It is in the way these samples were handled. It is in the kind of lab they deal with. Can we have the next slide, please? No. We know, and I know you know what this is about, when you take the swatches and you put them in plastic bags and you cook them for 7 hours, you degrade the DNA. And as we went through it, Dr. Cotton admitted it, Gary Sims admitted it, everybody admits it. It's fundamental. You can degrade the DNA so that there's none left that is detectable. And if you cross-contaminate it with another sample from a reference tube from high-concentration DNA, and remember, we're not talking about very much. The highest amount here is an RFLP test by Selmark of 25 nanograms. And you know, because we've been through this, that is, you know, such a small amount, less than a drop, a very small speck can create 25 nanograms of high molecular weight DNA. You know that now. I bet you before you came into this jury, you wouldn't have ever thought that you would be literate in this, but you are. You know this now. Okay, next. No, that's not it. Now, there's an issue of risk factors. And you have to assess what was handled here in terms of what is an acceptable or an unacceptable level of risk. Now, you remember all these logos. And I won't go through all of them, but handling multiple swatches in a hurry, handling samples from both crime scenes at the same time, not changing gloves, not routinely between samples, not changing paper and washing down between samples. When you scrape the swatches out of the tubes, creating aerosols, all these things create risks of cross-contamination. All these things, Gary Sims told you, their witness, were wrong. But the single worst thing that was done, the cardinal rule of handling these samples in a DNA lab, is the one in the upper right-hand corner. And that is handling Mr. Simpson's reference tube at the same time that you are processing the swatches and the glove. That is the biggest no-no that forensic labs have learned from bitter experience, as we'll discuss in a minute. What happened in the evidence processing room that morning? We know that Mr. Yamauchi says he got the sample at about 9 from Mr. Fung. And on cross-examination, he said something that was really remarkable. Do you recall this? all of a sudden he said, I remember now. I opened up the tube, and the blood spurted up through the chem wipe, and it got on my gloves. Now, he was a little vague about what he did with the gloves. He doesn't remember whether he put them in a biohazard bag right in the evidence processing room or got out, went to the serology lab, and got rid of them there. But all of a sudden, we now know there was a spillage of blood there. Now, that is extraordinarily significant because there's plenty of high molecular weight DNA in the smallest drop if you get it on your gloves or if you don't change the gloves. And frankly, I think there's no reason to believe he did, to contaminate these samples that we know are degraded. And it's so easy to do that and not be aware of it. And it's so easy to do that when you're in a hurry. And it's so easy to do that when you're only out of training for 6 months and you're in a tough position. And it's so easy to do that and not really be aware of it. So easy to make that kind of mistake when you really haven't had the training. So easy to do it when you're handling 21 samples that morning in one day, something that an experienced technician like Gary Sims tells you it takes days to do. So easy to make that mistake and cross-contaminate these samples. So easy. What's most important is that there's an unacceptable level of risk. You cannot accept this presumption that it all went right beyond a reasonable doubt. There's no way. Now, interestingly, when he says, even by his testimony, that he opened up the tube, the blood spurted out, let's give him changing the gloves, although there's no real reason to accept that, frankly. There's still, by his own admission, going to be blood on that table. Blood that you can swipe with your gloves or your hands, and it doesn't take much to do this transfer. He didn't wash down that table. There was no paper there that he changed. There's blood on the table. A fair inference. Now, the next thing that Ms. Clark said, and I don't know if she was listening to the evidence that carefully in this phase of the case, to be frank, is she said, well, if there were contamination, if there were DNA flying around from Mr. Simpson's sample, then we would have seen proof somewhere else that his blood had contaminated other samples. That's what we would have seen. Well, there was. On June 15th, if you recall, a second set of samples was handled by Mr. Yamauchi. He had the reference tube from the Cole Brown Simpson, the reference tube from Ronald Goldman, and he had item number 12, which were the 3 blood drops picked up at the foyer in Mr. Simpson's residence. Those were the last drops picked up that day. They were the ones that were last put in a plastic bag, and Gary Sims has told us those are the ones that had the highest DNA concentration of any of the samples. Item number 12. They are the one that got an RFLP result from Cellmark. So we know that item number 12 is high concentration DNA. We know that item number 12 was being handled by Mr. Yamauchi on June 15th with the reference samples of Goldman and Nicole, which are also high concentration samples. And Dr. Gertie showed you how at LAPD, and then on the polymarkers at Cellmark, and then at DOJ, we got typings that were consistent with cross-contamination from item number 12. And all the controls on those second days, those negative controls, are clean. Because, as I'll discuss in a second, we've already proven these things happen with negative controls being clean. You get this cross-contamination. So, this was proof that Mr. Simpson's DNA, by sloppy handling, was cross-contaminated and typed lab after lab. And you heard that on cross-examination, Mr. Clark didn't even confront Dr. Gerties with this board. And you know, he's a fine lawyer, and he knows this subject matter well. He didn't cross him on it. Because they can't touch it. In order for this to be true, the only thing they can say is, well, there was an extraordinary series of artifacts that accounted for some of it, but it didn't account for this polymarker typing. That can't be an artifact. It's proven. Thank you. And not refuted. And I should say one more thing in passing I forgot to mention, that when Dr. Gertie showed you his study of contamination at LAPD, when you have these negative controls, you can have contamination and the negative controls come up clean. In fact, in the instances where he saw contamination, 26% of the time, the negative controls were clean. And there's reasons for that, because these negative controls are not always going to pick stuff up. And you saw it right here. There's proof. Now, there's one other point to be made about this issue of cross-contamination at the LAPD. In that evidence processing room, we can't be any more specific about it. It's no flying DNA. And that is, you have to have an appreciation of how mistakes can happen with this technology. And we learned something about that from Dr. Robin Cotton. If you recall, the California Association of Crime Lab Directors gave a proficiency test where they used degraded samples in 1989. And in this test, they gave samples to Cellmark and to other labs, and there were false positives. And Cellmark got 2 false positives, the first and the second time. And you remember what Dr. Cotton told you about what they learned of that? When they did these tests, the second one in particular, the way that they got a false positive through cross-contamination is that they had a degraded sample. And the CACA study is the only one where they really are sending these labs degraded samples, just like here. There's a degraded sample, because that creates a risk of cross-contamination when you degrade out the initial DNA. And the only thing, do you recall this? The only thing they could isolate is that they were handling the reference sample at the same time they were handling the degraded sample. And what was interesting about her testimony is she testified that they had a witness in the room. In other words, when they were doing these proficiency tests, they were witnessed. Each transfer was witnessed by somebody standing right there. And all they could reconstruct at the end was that they had made a mistake This discussion started at 27517. Mr. Neufeld was asking, and you determined that it happened at some point during the extraction process. Yes, in dealing with the sperm fractions. But even to this day, Dr. Cotton, would it be fair to say you don't know how the accidental contamination occurred during the extraction process? Yes, that would be fair to say. Question, and it would also be fair to say that this cross-contamination, this accidental cross-contamination happened in spite of the fact that all of the sample transfers were witnessed by a second person to make sure no errors occurred. Answer, you are exactly right. Now, just think of the analogy. This is 1989. Actually, the second one also happened in 1990. This is when Cellmark was starting out. And even when they started out, they had far more qualified personnel than anybody that came in here from the LAPD. And they got a degraded sample, and they handled the reference sample at the same time, and they still can't figure it out. But that's when the cross-contamination occurred. So it happens. And it happened to a much better lab than LAPD. And it happened when they were just beginning. Just the way LAPD is just beginning here with far less trained personnel, frankly. So don't come in and tell us, based on this evidence, that it's unreasonable to suggest that there was cross-contamination, because all the evidence really, all the rational inferences point in that direction, that there was an unacceptable risk of it, and we have proof that it was going on with those samples from June 15th. Now, this leads me to a discussion briefly of numbers. We saw a lot of numbers in this case. And one of those numbers, as the judges instructed you, is what I guess is being called the random match probability. That is, what are the odds that somebody coincidentally has the same DNA pattern that they may find in some sample? And some of these numbers are pretty staggering. These are just frequencies, 1 in the billion, 1 in the trillion. Now, there are, frankly, some problems with these numbers. Dr. Weir, who came in here and testified that he's absolutely 100% right, and these people are just wrong, then offered you numbers which he had to admit were wrong and inflated and biased against the defendant. And Dr. Cotton, using Dr. Weir's methods, has come in here and told you that the database for a 5-probe match at Cellmark for an African American is based on samples they got from Detroit, and in terms of how many people have been tested on all 5 probes, and you get down to it, it's a group of people from Detroit and just 2 of them. So there are some problems with these numbers, but let's put them aside because they're really, in a sense, irrelevant to the main issues in this case. There's problems with them, and I don't think that you can just accept them at face value, but to find many reasonable doubts, they're really irrelevant. And the reason is that the issues in this case, as I'm sure you've realized, are how did blood get on these samples in the first place? Who put it there? Did they get there through contamination? Was there laboratory error? Was there corruption, contamination of these samples? That's the issue. So the numbers really are irrelevant. They're just telling you frequencies about samples, but it doesn't answer the question, how did the blood get there? Now, the judge has told you that laboratory error and these random match probabilities are different phenomena. They are. They're different things. And you know that from your own common sense. Let me give you a simple analogy. Let's say that we're trying to figure out the odds of somebody getting killed when they're walking across the street. There's lots of different ways that can happen. You could get struck by lightning. And the odds of that happening are probably like some of these random match probabilities, 1 in a trillion. On the other hand, if you're walking down the street, across the street, and it's a busy thoroughfare, and you walk out in the middle of traffic, the odds are greater you'll get hit and killed. If the cars are moving at 60 miles an hour, 70 miles an hour, the odds increase. If you walk out in the middle of the block, the odds are getting greater. If you're walking against the light, the odds are getting greater. The chances can be almost certain that you're making a mistake. So what you have to look at in assessing laboratory error are risk factors. And we know that the risk factors in the evidence processing room are unacceptably high, as Dr. Gerdes told you, unacceptably high. So if we could review. Are the Bundy blood drops cross-contaminated? We have to look at the history of this lab, a cesspool of contamination, unrefuted. The contamination, as Dr. Gerdes says, is localized in the evidence handling, exactly where it looks like it happened in this case. The risk factors in that evidence processing room are unacceptably high. We have contamination from that reference sample board on June 15th of Mr. Simpson's blood going into 2 reference samples with the controls being clean. And then we have the whole issue of Mr. Yamauchi spilling the blood. It's reasonable doubt. Now I'd like to turn briefly to the hair and fiber evidence. You heard from, Miss Clark can say it's his hair or it's this fiber. But as she had to say in her closing, that is not what the testimony was from the witness, because hair and fiber evidence, as Mr. Diedrich pointed out, and as we all know, and as Dr. Lee pointed out, is what they call weak association evidence. It ain't DNA. It is weak association. We're talking about broad similarities you can't even say the word match when you're talking about this evidence. It is really evidence by way of exclusion. We have to, they can't come up with a number and say this hair is, the odds of this being someone else's hair is 1 in 20. Can't even say that. It's just a question of looking at as many similar hairs to see if you can get an exclusion from a particular race. So there's no database, there's no number, it's just similarities. It is weak association evidence. Nobody is telling you that this is definitely somebody's hair is some particular fiber. Therefore, what you have to do with this kind of evidence, as Diedrich and Dr. Lee mentioned, is that you have to exclude other frequent visitors, for example, African American visitors to the Bundy condo area, if you're doing a serious assessment of whose hair, man or woman, older children of Mr. Simpson, younger children of Mr. Simpson, others who were there could be contributors of the hair. Fiber is no different. The same general class characteristics. A big deal is being made about blue-black fiber from some unknown source that's found on 3 objects and maybe more. Now we have Mr. Diedrich talking about the blue-black fiber at 35338, line 12 to 17. Question: do you remember what you told us in your direct examination about the amount of cotton fiber that is manufactured in the United States every year? Answer: 5 billion pounds. Question: okay, do you have any idea whatsoever of the number of fabrics of blue-black nature that looked black to the naked eye and were distributed in the Los Angeles area in the past 5 or 10 years? Answer: I have no idea. You want to say 10%? What's 10% of 5 billion? Look around the courtroom. How many people are wearing blue-black cotton fibers? Maybe some of you right now. So you have to look, when you're assessing this evidence, at background. Who could be contributing these hairs and fibers? And you can't say anything certain at all about the similarities. It's weak association evidence. We know that Mr. Simpson is a frequent visitor to the condo area. You would expect to find his hairs around there. You would expect to find bronco fibers around there, not just from Mr. Simpson, but from Nicole Brown Simpson, from the children, from others who were in and out of that Bronco that's used as a utility vehicle. Just as a simple illustration, Dr. Lee, this is a soil exemplar that the LAPD took. They never made an assessment of the fibers. Here's hair and fiber that you just see in the soil from that closed-in area. It's okay. It's around everywhere. We shed them, it comes out, it's all around an area where people live. Now, one interesting character that could be a source of all these is Cato the dog. After all, Cato the dog is probably, in that closed-in dirt area, one of the most frequent visitors. And Cato the dog is carrying hairs from all the significant members of the family, and he's carrying bronco fibers with him because he's a dog that shed. I had a sheepdog. You all have dogs. You know that that is a phenomenon. And Cato the dog, as we'll see, and it's a significant point, was at the crime scene that night. In terms of assessing hair and fiber evidence, you have to look at the issue of contamination. Particularly when you're talking about hair and fiber flying all over the place at a crime scene. I mean, this is where the issue of contaminating a scene is of critical importance. And how did they handle this scene? We have the issue of the blanket. I mean, this, as Mr. Fung admitted, was colossal stupidity. To take a blanket that people, that Mr. Simpson and others with bronco fibers, hairs from all kinds of African Americans on that blanket, and then throw it out over the crime scene, over the bodies, over the evidence items, everywhere, is asking for trouble. But perhaps the most significant problem here, and it's the one they haven't come clean on in this case at all, is dragging around the bodies. This was, in terms of handling a crime scene, this was really an incredible thing. Because if you're trying to make associations about hair and fiber evidence from clothing of the 2 victims and what might have been in the dirt area where people are shedding these things all, and you drag the bodies all over the place, over the evidence that you're testing, There's no integrity to that. It's ludicrous. And nobody ever came clean and said who it was that moved those bodies through the envelope and the hat. And we all know that happened, right? They have to admit it happened. When they pulled Mr. Goldman's body through, or Lord knows what was going on, it was all moved and replaced, and nobody's ever come back and told you who put the envelope back in a different position, who put the hat back in a different position, who put the glove back. Nobody's ever come in and told you. And they certainly didn't investigate. We'll talk about that a little bit more. But we put in concrete evidence that this kind of cross-contamination was going on in the hair and fiber evidence. Could we have the next slide? These were slides that were put in evidence by Mr. Blazier, if you recall. And this represented something really interesting. It had to do with blood stains blood evidence that you found on the clothes, the dress of Nicole Brown Simpson on the left, and the shirt and the jeans of Mr. Goldman on the right. And if you recall, there was not only blood evidence, stains on the bodies themselves, but there was also in the area where they were taking controls. You know, you try to find an area where there's no blood stain, you take a control, and those controls came up showing evidence of Nicole's blood on Ron's shirt, vice versa. Could we have the next slide? What is the exhibit number? I'll get you that. These are in evidence. The summary of the results were, on those clothings, go back, please. Summary of the results, there were 23 stains tested. 16 of those stains showed carryover. And very interestingly, if Mr. Simpson supposedly committed these murders and his hand was cut and he's struggling here, no matches, no evidence of his blood on this clothing. But there is carryover between the clothing. Now, what does that mean? That means, frankly, that the bodies were dragged through the crime scene and blood from Nicole's Brown Simpson got on Mr. Goldman and vice versa. And if that happens, that's how the fibers can get carried over too. And Ms. Clark went on, and I think she even put some, little pieces of the puzzle up there. She went on with this rank speculation where she was saying, well, we know that it was one killer. And we know it was one killer because we saw some fibers that came from Nicole's dress and got on Ron's shirt or jeans and then back and forth. And that's how we know that one person was going back and forth between two victims. Nonsense. This proves it. This proves that the hair and fiber and the blood evidence were all coming together because the handling of this crime scene is a disgrace. A disgrace. They're dragging the bodies back and forth. Okay. Now, also, it should be noted that it came out during the testimony of Ms. Brockbank that the two gloves and the two hats, the knit hat and the plaid hat found in Mr. Simpson's Bronco, and the Bronco carpet that was cut out of the car, were all placed in the same box. I mean, the way they handle this stuff, and then they want to come in and say there's integrity to the hair and fiber evidence, is ridiculous. Briefly on the hat, we had testimony about dandruff. You heard Mr. Simpson's barber say that in the off-season, in the summer, in spring, he gets dandruff. Right after he's arrested, they remove known hair samples. His hair has dandruff. There's no dandruff in the hair in that hat. Now, if we look at the hair and fiber evidence as a whole, there are, and this is just weak association evidence, nonetheless, there are powerful inferences consistent with innocence. And these were put on slides that are in evidence. I'd like to review them briefly with you. Both gloves, no hair consistent with Mr. Simpson on the Bundy glove, no hair consistent with Mr. Simpson on the Rockingham glove. That's the slide we put up. But you know what we should have added to that slide? Very significant facts that I hope you don't forget. There was an unidentified Caucasian hair on the Rockingham glove. Did they test Mark Furman? Did we get a hair exemplar from him? Also, and this is a fascinating point, Cato the dog. his hair was found on the Rockingham glove. And I'd like you to read this testimony to you because I don't think it was an answer that Miss Clark particularly liked. And this was in the cross-examination of Mr. Diedrich. Question. And they were talking about Cato's hair, and page 34949 of the transcript. Is the finding of such hairs, Cato hairs, on the Rockingham glove accounted for by possible contact between the wearer of that glove, the murderer, and Cato the dog, either during or immediately after the murders? Answer, could have. It could have been a direct transfer for the dog, or as I stated before, an indirect transfer from hairs at the crime scene. Question, that were, say, where? Answer, on the ground maybe. Would have to have been on the ground. Question, have to have been on the ground? Answer, or perhaps from one of the victims who had been on the ground and collected the hairs. Question, and that you have previously described those as being common to the under part of a dog as opposed to the tuft or the coat. Now he's talking about the hair. This was a soft hair from Cato the dog found on the Rockingham glove. Answer, okay. It may be just a matter of semantics here. When I say the under part, under the fur, under the out of coat, which could have been on the belly, it could have been on the back, but it is just the soft, fine hairs that are closer to the body. Question, if that dog used this shaded place to sleep or lie down on a regular basis when it was in the Bundy residence, might you expect to find some fur hairs left behind in the soil? Answer, I would expect that, yes. Question, and if the Rockingham glove were deposited any time on that soil, the Rockingham glove being on the Bundy soil in the closed-in area, were deposited any time on that soil, might that not explain the presence of those hairs? Answer, it could, yes. So very simply, he's saying that this is hair from the soft underbelly of Cato of the dog, the kind that you would expect to be shed if he were lying on the ground there, not the kind that you get if the dog sort of pats you, all right, or it comes up on you as they're going to probably claim, fleeing the crime scene or something. It's a soft hair. It's the kind that you would find on the ground in the closed-in area. What does that mean? That means that Rockingham glove started at Bundy. Somebody took it somewhere else, and you know who that was. Let's go on to the next slide. The socks. There's no fiber on the socks consistent with either glove, and these are cashmere gloves where cashmere would easily come out and get on your hands, transfer to the socks. No fiber consistent with Mr. Goldman's clothes, and we know there was hand-to-hand combat here. No fiber consistent with Nicole Brown Simpson's clothes. Nothing on those socks. Also, we should add, no soil on those socks, no trace, no berries, nothing. Pretty interesting, those socks. Next one, please. As far as the hair is concerned, no hair from Mr. Goldman, no hair from Nicole Brown Simpson on those socks. Next, please. As far as Bronco fiber is concerned, no Bronco fiber is found on either glove. No fiber consistent with Mr. Goldman's clothes is found. No fiber consistent with Nicole Brown Simpson's clothes is found. Next. As far as hair, no hair consistent with Miss Brown Simpson, no hair consistent with Mr. Goldman on the Bronco. Okay, and I should add, in the Bronco, what they did is not only did they take out that carpet, but they went in and they vacuumed it. They vacuumed it to get all the hair and trace. They vacuumed it. And even Mr. Diedrich himself, when he was talking about hair transfer, said, well, the way it would get transferred is when you sit down in your car, things would come off. There's nothing in the Bronco. How can that be? Now I'd like to move on to the crime scene at Bundy and evidence of struggle, the testimony of Dr. Baden and Dr. Lee. And I guess Dr. Lakshmanan, who came in here as the person for the prosecution to try to reconstruct that crime scene. There are bloodstain experts and criminalists and people like Dr. Lee out there prosecution could have called to come in here and try to assess this evidence for you. They did not do so. They brought you Dr. Lakshmanan working over section generation photographs, who was a coroner, to do only one part, or as best he could, with this evidence. Now, we know, as Ms. Clark indicated in her closing argument, that Nicole Brown Simpson did struggle before her death. And we know that there were defensive wounds on her hands. And we know that some of the wounds to her neck showed evidence of struggle. And then we have the fingernail scrapings. Now, Mr. Sims had said that he would expect that when you did fingernail scrapings, you would find, excuse me for just a second, he would expect that there would be skin under the nails. Now, he's a fine man and a fine forensic scientist. I have no quarrel with him, but he was admittedly testifying in an area outside of his expertise when he told you. He was saying that was his common sense understanding. But Dr. Baden came in and testified about what one ordinarily finds as a coroner with fingernail scrapings. Dr. Lakshmanan didn't dispute it, and that is that with fingernail scrapings, when you find it, you find blood under the nails, but you don't find skin, because when it grabs, the blood comes up, but the skin doesn't come with it. That's what Dr. Baden says you find. That's what the textbooks say you find when you get fingernail scrapings. So you would get blood, but not tissue. So let's explode that myth right away. But now we have the problem for the prosecution that when they do the fingernail scrapings, they come up on the EAP system with a B. That is not O.J. Simpson's type. That is not Nicole Brown Simpson's type. That is not Mr. Goldman's type. It is some other person. And that's what their typing results showed. And so then it doesn't fit. It can't be right. So we have to see if we can make an assessment that would somehow undercut that finding. Now remember, when you have two conflicting reasonable interpretations of evidence, in a circumstantial evidence case, you have to go with the inference that's consistent with innocence. Now let's look at what happened. Mr. Matheson said, I think what could be here is that we had, can we show this slide? A four-banded BA from the Nicole Brown Simpson that degrades into a two-banded B. Now, you recall this testimony, I'm sure, and the cross-examination by Mr. Blazier, and the testimony by Mr. Sims, who'd been doing serology a lot longer than Mr. Matheson, had a lot of experience in conventional serology. These are the facts. The facts are, in the literature, this supposed degradation pattern that Greg Matheson suggests could occur does not exist. There is no literature. Dr. George Sensabaugh, all the experts in this field, that doesn't happen. Nobody has seen it. Mr. Sims, who did more conventional serology than Mr. Matheson, said he, in his experience, has never seen a four-banded BA degrade into a two-banded B. Never. Mr. Matheson says he thinks he recalls somewhere he saw it. That ain't good enough. That kind of maybe I saw it, that ain't good enough. Maybe doesn't cut it in a criminal case. We're talking proof beyond a reasonable doubt. This is nonsense. Now, the other thing that they're trying to say is, all right, you can put aside the EAPB because there was DNA testing of some of that material under the nails, and that came back as 1.1, 1.1 Nicole Brown Simpson's type. And they think that you're not going to understand this. But you do. Because, as you heard, the EAP system is a red blood cell. A red blood cell does not have a nucleus. There's no DNA on the red blood cell. The EAP typing system is something that looks at antigens on the outside of that red blood cell. So you can have blood under that nail, small amounts of blood under that nail, test out to an EAPB, and then when you get the little bed of epithelial cells under the nail, all right, or even some other things, that blood that might have come in there from the Colbrand-Simpson, that can type out 1.1, 1.1. But the initial scrapings, when they ducked down, they came up with the EAPB. And you can't get around that. And you can't try to explain it away. And they don't bring in any serologists. Now, even Mr. Sims, and he's not a doctor, Mr. Sims, the best that he could do in looking at all of this, when they finally asked him the question on page 28748, he said, well, looking at all these findings, I can't exclude the possibility that the EAPB, or that might have been from the Colbrand system. I can't exclude the possibility. That is not exactly a firm statement. That is, again, a maybe. And a maybe doesn't cut it in a criminal case. And when you have two reasonable conflicting inferences, you've got to go with the one consistent with innocence. And that's what this evidence shows. That's fact. I'm not making any of this up. Those are facts. Okay? Now, oh, no. Do you like a...
You want a glass of water? All right. Sure.
Something I said. Now, can we have the board? There's the whole issue of Mr. Goldman and his struggle with perpetrator or perpetrators. There were 30 stab wounds inflicted upon Mr. Goldman. Ms. Clark told you about, well, there were cuts on his hand, his open palm, sure. But what does that mean? If there are cuts on his hand and he is struggling with an assailant, it gets on the clothes of the assailant. Dr. Lee did an analysis of the scene based on the limited evidence that he could get, because they didn't document it in any way where you can do a good reconstruction, just a limited reconstruction. And we had multiple contacts, blood transfers in different areas of the closed-in area. And in each of these different areas where the multiple contacts occurred, as you recall, there were also vertical blood drops. And the fair inference from that evidence is that there's a struggle, people are up against one area, then another area, up against the other area, blood drops are going down. So there's struggle in different areas with an assailant or assailants. I mean, we can just reason from facts. We can't. Dr. Lakshmanan got up, and there's a whole hypothesis here that it all happened so quickly by surprise, stealth, surprise. I mean, you can't do that. You've got to look at facts. You've got to do a best analysis, a fair inference from the facts. And the facts show that there's multiple contacts in these different areas from the bloodstain evidence by the world's leading analyst of this, whose testimony on these points stand unrefuted. There is, of course, as we've discussed, the dugout area, particular struggle here, as even Detective Lang told you, where there's, and other areas where there's signs of struggle between the assailant and Mr. Goldman, soil on the socks. There's contact by the way that they're banging against the sides of the gate, such that pants are going to come into contact with pants and shirt. Now, it's clear from the way this struggle went that at some point early on, Mr. Goldman sustained this wound to his neck, and the blood began oozing down. And as Dr. Lee pointed out, he had to be standing, Dr. Baden had to be standing vertical for some period of time because the blood did go down from his shirt all the way down his pants leg. And we saw blood, a lot of blood on the back of his pants. Now, if assailants are struggling together, there's going to be blood from the pants, blood from the shirt, in close contact, transferred to the assailant. Gotta be. It's a bloody struggle. And that's what this bloodstain evidence shows you. It's fair inferences from the facts. Now, the beeper and the keys. The significance, I submit to you, of the beeper and the keys at the very least, put aside keys as weapon. Just the significance is thrown, you know, there's violence, tussling and struggling. The beeper is thrown down here. In the other area, another area of struggle, the keys are thrown down. If the keys are in the pocket, that's got to be a considerable tussle because for the keys to come out of the pocket in the other area. Or if the keys are in his hand, well, he's going to use that as a weapon. So you can't, you can't have it both ways. It shows multiple banging and struggling throughout that area. Now, the key fact that Ms. Clark conceded in her closing argument, key fact, is what Dr. Baden told you about the time between the wound in the neck and the time to the last fatal wound in the chest. And this is just fact. As Dr. Lee would say, there's scientific fact, there's interpretation. We deal with fact. The fact is that this wound had to come first, the one to the neck. There's blood oozing down. And the last wound is to the chest. When the wound in the chest occurred, as Dr. Baden told you, there's only 100 cc's of blood in the chest. What that must mean is that by the time Mr. Goldman was stabbed there, his heart was compromised. It wasn't beating very hard. So you did not have the amount, much more than 100 cc's of blood you would expect to find in the chest if it hadn't been the last, if not about the last wound. And Dr. Baden said, from the time, just based on finding 100 cc's in the bleeding, a compromise of the heart, the time between the first stab and the last stab would be between at least 5 minutes, as much as 15 minutes, most reasonably 10. Now that doesn't mean that the struggle went on from the first wound to the last wound for 10 minutes. What it means is, and this is what's crucial, that the assailant or assailants were there for that period of time. Could be that Mr. Goldman was subdued, was lying on the ground, and they did come and stab him last and make that last wound. But we know from the facts that between this wound and the wound to the chest, most reasonably 10 minutes. Somebody's there, at least some people are there for 10 minutes. Now, if the struggle occurs, starts 10:35, 10:40, based on scientific fact, Mr. Simpson can't be guilty of these crimes. Because he can't be two places at the same time, can he? Now, that time period is even, longer. They say, oh, take the 5 minutes. Give us, the prosecution, the inferences. Well, you can't. You can't. Because reasonable inferences, if it's between 5 and 15, most reasonably 10, you got to take 10. You can't give them the 5. That's not the way you can reason about a circumstantial evidence case. But even if you take the 5, something happened before that first wound, some period of time. So the window, the time here that these murders took is not this incredibly quick event that is necessary for the prosecution's timeline. And that's based on a reasonable, careful, scientific investigation of the evidence by Dr. Baden, one of the foremost pathologists, and Dr. Lee, one of the foremost forensic experts. This is evidence. Now, the next thing I'd like to point out has to do with the bloodstain imprints on the envelope. Oh, I'm sorry. I forgot this. Thank you very much. One other thing I should mention about the struggle. It's a critical point. I can't believe I left it out. How did...
It's on this board. Are there remains on this board?
No. Where did this come from? Dr. Lee testified that it is a fresh cut. You can see when you examine the clean part of the top here, the interior. It is a fresh cut from a sharp instrument, consistent with a knife. Think about that. Think about that. What does that indicate about the nature of this struggle? Mr. Goldman, one or two assailants, somebody coming towards him, he kicked. Dr. Lee testified that by the angle, that is consistent with the foot being raised in the air and a sharp instrument coming down. There's kicking. And if there's kicking, why are there no bruises on Mr. Simpson's body consistent with that kick? And why didn't anybody else come in here and point out this cut on the boot? Very significant evidence. And of course, there's the dirt on the boot that you would expect to see, and the blood on Mr. Goldman's jeans, and the broken buttons, indication of struggle there. Now, the bloodstain imprints on the envelope. Now, I know it's not Mr. Bodziak's area, but you have to consider all the evidence. And Dr. Lee, I think, gave us all a pretty sound education on bloodstain interpretation, enough to basically figure out and understand which blood stains, that certain deposits are made first, then other deposits are made over them. And I think that that's, pretty significant in terms of assessing this. Now, the first point that I think this goes to is, you recall Mr. Bodziak's testimony that there could only be one set of footprints leaving the scene. And when you analyze it, he concedes that that was based on the assumption that there was a pool of blood that all assailants would have to walk through. And I understand that he was not following all of Dr. Lee's testimony, only, I guess, 95% of it that dealt with footprints, but not the full 95% as I originally thought he was saying. But the point is, it's like you forgot about Dr. Lakshmanan. Dr. Lakshmanan offered a scenario in broad respects that Dr. Baden said could well be the case, and it seems to be an operating premise here. And that is that Ms. Nicole Brown Simpson was subdued. She could have been hit on the head. It wouldn't necessarily knock her out, as Dr. Baden indicated, but might have incapacitated her or knocked her out. And then there's a struggle with Mr. Goldman, and then, or as close to the final act, Ms. Nicole Brown Simpson's leaning over the stairwell, is inflicted with the last wound to her neck, and then the huge blood pool occurs. But if you're not necessarily, and that is the assumption underlying Agent Bodziak's testimony, that if there were to be another set of footprints, it would have to be dark from a big pool of blood. It's not consistent with what Lakshmanan said. There could have been one, two other people left that scene, somebody without leaving that tracks. They could have come out the way that the police did, which wouldn't leave imprints. Or there could have been partial imprints with small amounts of blood on the shoes that were not discovered because, frankly, they were not looking, as you can tell, very hard or very aggressively for anything other than focusing in on those Bruno Magli shoes. And I realize Agent Bodziak thinks very well of the photography of the criminalists at the LAPD, but taking good photographs of one's Bruno Magli shoes does not mean that was combined with does not mean that they were looking for other imprints, as his book recommends that people do, and do aggressively. Now, the one really interesting part of this envelope has to do with its handling. Do you recall Dr. Lee pointed out on the far right-hand corner that this is a mirror image stain, meaning that it had to be a wet deposit, and then somebody folded the envelope. So the blood is wet and the envelope is folded. And then we see, could we have the next? This is what number, I'm sorry? 1348, as he focused in, is what appears to be consistent with a light transfer of a finger. Next. Next one. No,